Religious Accommodation in Corporate America by Colby McGrath. What is religious accommodation? Before moving on, it is first important to have a firm understanding of what exactly religious accommodation entails. Under Title VII of the Civil Rights Act of 1964, employers are prohibited from discriminating against employees based on their religion, race, color, sex, or national origin, and must accommodate the dearly held religious beliefs of their employees so long as the accommodation does not impose an undue hardship upon the business. We'll approach the subject of how an undue hardship is defined later, but a general definition found on the Equal Employment Opportunity Commission's website defines an undue hardship as more than a minimal burden on business operations. So, to provide an example, it would be reasonable to accommodate a Muslim woman who needs to wear a hijab to work, but it would not be reasonable to accommodate Mark's request to take time off for the month of March to watch monster truck rallies, an important religious holiday under Mark's newly founded religion of monster truckicism. In general, it seems straightforward as to where a line should be drawn, but things aren't always so black and white when Title VII comes into the mix, as there are countless variables to take into account from workplace to workplace. How does one define religious beliefs? Going off of the example from the previous slide, it is plain to see that a line needs to be drawn at some point when deciding upon whether or not a belief should be protected. Religion is a generous term under Title VII encompassing not only traditional religions, such as Christianity, Buddhism, and Judaism, but also more obscure religious beliefs held by a smaller group of individuals. Even if a religion was only recently adopted or not consistently observed by an individual, it could still be dearly held. In the bottom left hand of this slide, you will find pictured the Flying Spaghetti Monster, which is the deity of the Church of the Flying Spaghetti Monster. Whilst Russell Coyer, a lawyer at Texas-based firm Kelly Hart and Hallman, holds that an employee who claims membership in this religion should be protected under Title VII so long as their beliefs seem dearly held, members of this religion are not generally genuine in their beliefs. This religion is typically used, particularly by its members in the media, to lampoon some social issues presented involving religions, such as teaching intelligent design in public schools, global warming, and religious holidays. Due to the fact that this system of beliefs is more a social movement than a religion, it would not be protected under Title VII, and so an employee claiming membership would likely lose their case if it were to make it to court at all. In addition to social movements, political and economic philosophies along with personal preferences are also not religious beliefs under Title VII. Why is religious accommodation relevant? For individuals who plan on going into any professional setting, understanding how diverse religious beliefs mix and meld within a workplace is of the utmost importance, especially with how much attention political correctness is given nowadays. Global media pushes certain preconceived notions about various religions onto the general public, presenting Muslims as being violent, Christians as acting out in regards to sexual orientation and abortion, and Jehovah's Witnesses as being ridiculous for not accepting blood transfusions. While people might agree with some of these stereotypes, it's important to realize that most of them are founded on the notion that you can generalize an infinitesimally small sample size to an entire population. Ultimately, we will look into how religious beliefs are upheld in the workplace, analyzing how multiple conflicting belief systems can function within one office. Jose Alcantara versus Bed Bath & Beyond Inc. and Kelly Marsali. This trending case does not focus solely on religious accommodation, but it does show what can happen in a business environment where members of protected classes are discriminated against. The case follows a Muslim man named Jose Alcantara who was terminated at the beginning of 2014 after a period of employee-led harassment involving his religious beliefs. Following the death of a family member, Alcantara grew closer to his faith and grew out his beard, as is often done in Muslim culture, in order to feel more spiritually connected to his religion. Upon growing his facial hair out, his colleagues started asking questions about his religion, allegedly going so far as to greet him as a terrorist each day. His manager, Marsali, whom Alcantara was a department manager directly under, spearheaded the campaign against him. This allegedly led to Marsali changing Alcantara's vacation days without his knowledge, leading to his termination for absenteeism. Had Alcantara's superiors nipped this issue in the bud by graciously acknowledging his beard when brought up, reprimanding his coworkers for the harassment, and acting in a professional manner, this issue never would have happened, and so it seems to be a well-suited example of what can occur to employees whose religious needs are not accommodated sufficiently. It was submitted in November to a U.S. District Court in New York, but further developments are expected as the EEOC provided a right to sue letter. The EEOC versus Abercrombie & Fitch Stores, Inc. This was another trending case for quite a while, but unlike the previous case, this one has already been ruled upon. A quick summary of this case is that Alaf, a practicing Muslim here represented by the EEOC, applied for a job at Abercrombie & Fitch, and the records show that she was turned down due to her hijab. The decision was appealed by Abercrombie on the basis that she did not state that her hijab was part of her religious garb. Ultimately, the case was heard in the Supreme Court, resulting in an 8-1 ruling in Alaf's favor. The Supreme Court stated that Alaf did not have to submit a request in order to be protected against religious discrimination under Title VII. This case displays a strong precedent in what can be viewed as religious discrimination in hiring practices. Conflicting religions in corporate America. The legal issue that I've been most interested in is how companies go about resolving instances wherein one employee's beliefs conflict with those of another employee. As American workplaces become increasingly diverse, conflicts unsurprisingly arise in the seemingly most innocent of ways. Someone stating "God bless you" might seem like a friendly gesture in some circles, but many individuals might feel uncomfortable by hearing statements alluding to a God that they don't believe in. The question then becomes whether or not one religion should be given preferential treatment over another, given a situation where both sides seem to offend the other. While that's a complicated topic that has had a number of diverse rulings over the years, the EEOC tends to support that conversations about religion in a workplace cannot be restricted any more than other forms of expression that might have a similar impact on workplace efficiency. So, as Berkeley Law School graduate Lisa Guerin puts it, if a company allows employees to have arguments in the workplace over politics, it would be tough for that company to crack down on only religious discussion topics. Why I chose my topic. As someone who's interested in moving on to the professional setting, I find it important to understand the diverse opinions of those I work with. My views are generally pretty neutral on topics such as religion, but a great many people might come into work with a far stronger opinion than I possess. Learning about different religions and cultures will ultimately lead to a better understanding of topics that might make another worker uncomfortable or agitated. In addition to a better understanding of the viewpoints of other workers, seeing the trends in religious accommodation case rulings provides more insight into the legal system as a whole. I'm no legal expert, not even close, but law is one of our primary forms of governance, and so understanding it better is certainly never a bad thing. Status of this issue in the legal system. The aforementioned case of EEOC versus Abercrombie & Fitch is one of the more recent examples of cases pertaining to religious accommodation in the workplace. Whilst it does not necessarily deal with two conflicting opinions between employees, it provides an excellent indicator as to where religious accommodation rulings will likely be heading in coming years, especially when taking into account that the decision came from the Supreme Court. Title VII remains the primary applicable course of legal recourse when dealing with issues of religious accommodation and discrimination within the workplace. One change that Title VII is currently facing comes in the form of the Workplace Religious Freedom Act. This act would make it more difficult for employers to prove undue hardship when accommodating religious beliefs, and is highly controversial due to that fact. Scholarly analysis of the issue. In a Notre Dame Law Review, James Sun takes his time in explaining what the Workplace Religious Freedom Act, also known as the WRFA, is, and what far-reaching implications it has. Starting off, Sun pokes fun at the issue by presenting a job applicant whose religion requires him to scry into a crystal ball while holding a snake 10 times a day, mentioning a myriad of other supplemental demands that the potential employee would have under his faux religion. He goes on to explain how in Title VII's current state it would be reasonable to turn down the employee's demands, but also explains that if the WRFA were passed, it would drastically alter that ability. Under the WRFA, an undue hardship as defined under Title VII would change from being defined as the employer is unable to the employer is unable after initiating and engaging in an affirmative and bona fide effort. This change might not seem significant with such a large document, but one should never underestimate the power of a single sentence, especially when it comes to defining essential terms. Past rejecting a religious accommodation claim, employers would be required to be able to demonstrate the efforts they took in hopes of accommodating their employee, and how they fell short. Sun believes that mandating religious accommodation in most all instances would be an affront to the moral fiber of employers who tend to already help with religious accommodation cases. Past Senator Jennings Randolph mirrored this sentiment, stating that only the most extreme cases would require such mandatory accommodation. Scholarly analysis of the issue continued. Hutton and Grissom present another interesting viewpoint on current trends under Title VII. They acknowledge that religious discrimination is a growing problem within the workforce, citing growing religious diversity as a major reason as to why there has been an 87% increase in religious discrimination charges filed with the EEOC over the last decade. Another important topic that is discussed at some length involves grooming practices related to religion and how they are to be handled in a professional setting. For a vast majority of cases involving reasonable grooming that is influenced by religious beliefs, the employees are accommodated. The journal discusses the case from earlier involving Ilaf and her hijab. However, analysis of the case relied upon an earlier appeal that sided with Abercrombie, and that ruling has since been overturned in favor of one that agrees with the notion that companies act in a reasonable fashion towards people in similar religious garbs. This journal ends on a hopeful note, stating that the case law will evolve with changes to religious diversity in the American workplace. My thoughts on the matter. As stated by Hutton and Grissom, religious diversity is increasing rapidly within the American workforce. As such, the need to accommodate diverse and often conflicting religious viewpoints will present itself more commonly in coming years. The WRFA does not seem like the most solid amendment to Title VII in its current form, primarily due to the fact that the definition of undue hardship puts far too much on the employer. Ultimately, religious accommodation will play an important part in most all upcoming Title VII rulings, and will continue to change along with the religious climate of the United States. Conclusion. In the end, religious freedoms and accommodation in the workplace walk along the thin line between what one employee is comfortable with and what another is uncomfortable with. It's incredibly difficult to deal with religious allowances in a workplace without making it feel as though you're imposing them upon someone else. That said, conflicting religious beliefs should never be a reason for employee discrimination, termination, or rejection. These practices are outwardly un-American and have been ruled against time and time again. Moving forward with full awareness of the fact that the aforementioned acts are wrong, we look to smoothly integrate individuals with diverse outlooks on religion into the same workspace.